All right. Thank you and welcome. And Maripat, why don't you take it away?
Great. Thank you so much. And thank you, everyone, for joining today. We're here to talk about public charge. Yet again, as Sandra said, we've been fighting this for a long time, and there have been some very recent developments. So I wanted to get back with everybody now to talk about what those developments are and what the next steps might be. I am an attorney, a public benefits attorney at Community Legal Services in Philadelphia. I am not an immigration lawyer, but because public charge implicates both immigration law and public benefits law, I've been spending a lot of time over the last couple of years studying this topic and thinking a lot about how it might affect people's access to public benefits. So we're going to focus today on people's access to public benefits, but also talk about the potential implications within immigration law and people's ability to adjust their status and move forward in their immigration cases. This is what I hope to cover today. I hope to answer these first two questions for all of you today. First being, what is public charge and who is subject to it? Then what are the rules about who is a public charge and how are those rules changing? Then I also hope to leave you all with these 2 points made here, number 3 and 4. The large majority of people can safely continue to receive the public benefits they are eligible to receive without harming their immigration status at all. And then this fight will continue. Many of you might know that there was a Supreme Court decision at the end of January that is changing things, but this fight will continue, the litigation will continue, but then also all of the other advocacy around public charge will continue, and you can help in that effort. So we will talk about that, of course. And then I do intend, as Sandra said, to leave room for your questions, and I hope that we have some time at the end for some case examples, because I think that they really help folks to think through these sticky issues and how they might affect immigrants in the community. So on that first question, what is public charge? Public charge has been a part of federal immigration law for a really long time, since the 1800s. And when I say federal immigration law, I mean the statutes, right, that have been passed by Congress. And those statutes have not changed at all. They have not changed since 1882 on what public charge is and how it can function within people's immigration cases. And so one of the things that the federal law does is it creates this public charge grounds of inadmissibility. And under that public charge grounds of inadmissibility, immigration officials can deny visas or green cards to some people if the immigration official finds that that person applying for the visa or the green card is likely to become a public charge in the future. And now I highlighted here the words visas or green cards, and then also to some immigrants, because those are really key words here. The public charge grounds of inadmissibility is only about visa and green card applications, and it's not even about all visa and green card applications. There are lots of people who are exempt from this public charge grounds of inadmissibility altogether. So it's just about green card applications and visa applications. It really is about nothing else. Public charge cannot be used to deny a U.S. citizenship application, a green card renewal. So green cards, once you get your green card, you adjust to become a lawful permanent resident, you get your green card. That green card is good for 10 years. And so if you need to renew it after 10 years, you can't be denied that green card renewal because of a public charge problem. Asylum applications cannot be denied on public charge grounds. DACA renewals cannot be denied on public charge grounds. Temporary protected status applications and renewals cannot be denied on public charge grounds. VAWA petitioners cannot have their VAWA petitions denied because of public charge. UNT visa applications cannot be denied on public charge grounds. Special immigrant juvenile status cannot be denied because of public charge, and some more. So lots of people, just thinking about my particular immigrant client base here at CLS, this really covers a lot of folks. A lot of folks are in one of these groups who don't have a public charge test coming up in their future immigration case. In addition to all of those applications that can't be denied on public charge grounds, there are many people whose green card and visa applications also cannot be denied on public charge grounds. So lots of people, these are all the folks who are exempt from that public charge grounds of inadmissibility when they're applying for their green cards. Refugees cannot be denied green cards. Asylees cannot be denied green cards. VAWA petitioners, special immigrant juveniles, UNT visa holders, all of these folks cannot be denied green cards on public charge grounds. They are exempt from the public charge grounds of inadmissibility. And these exemptions are, like I said, part of those federal laws that have, those statutes that have been passed by Congress and that have not changed. And they cannot change through any action that the Trump administration takes through the new rules that they're passing around public charge. These exemptions will stay in place no matter what happens with the Trump administration's public charge rule. So if you are in, one of these groups, within these groups of folks who are exempt from public charge, you can continue to get any public benefits you're eligible for without any risk to your immigration status. And this really covers pretty much everybody who is eligible for any of the public benefits that create some public charge risk. Almost all of these folks who are eligible for those public benefits are also exempt from public charge. So if they are eligible for medical assistance or food stamps or cash assistance, all of these folks can continue to receive those benefits without any risk to their immigration status or to their citizenship if they've naturalized. Who are we left with? Well, the main group of people who have some potential, have a public charge test coming up in their future are people applying for green cards or visas on family petitions. So these are folks who will need an affidavit of support filed by a family member who's petitioning for that person to immigrate to the US and join the family in the US, and their eligibility for their green card is based on that family relationship. For those folks, these folks have a public charge determination, a public charge test that they will have to pass in order to get their green card. And if they don't pass that test, that can result in the denial of their green card or their visa application. Note that I have used a yellow slow down color here, not a red stop sign color here. These folks should not, just because they have a public charge test coming up in their future, that does not mean that they should disenroll from all their public benefits and stop their immigration case in their tracks. They should slow down and they should think, talk with their immigration lawyer about what public charge means for them, talk with a public benefits expert about what public benefits they might be able to safely receive. But for a lot of folks who have a public charge test coming up in their future, probably they can continue to get the public benefits they're eligible for, and probably they can work with an immigration lawyer to figure out a way to pass that public charge test. But they should slow down and think about it carefully. All right. So for that small group for that relatively limited group of immigrants who are filing for green cards and visas on family petitions and who have this public charge test coming up in their future, there are two potential arms of the federal government that will be making the decision about whether or not they are a public charge. If folks will be applying for their green card or visa here in the US, if they will have that application processed here in the US, the Department of Homeland Security, through the United States Citizenship and Immigration Service, or USCIS, will be making that public charge determination for them. If the person who's applying for the green card or visa is currently overseas and will be applying from overseas for the green card or visa, or if somebody's in the US now but will need to leave the US in order to apply for their green card or their visa from outside the US, the Department of State will make the public charge determination for that group of people. We have been focusing a lot here on the Department of Homeland Security's rules, so the rules that are in place for people who will be going through this process inside the United States. There are a couple of reasons for that. The first is you have to be here in the US in order to access public benefits, right? So typically, if somebody is going to be thinking about disenrolling from public benefits, they're going to be somebody who's here in the US and will be going through this process of the public charge determination and the green card application process here in the US. Also, the Department of Homeland Security has been the main agency that's been creating a lot of the rule changes around public charge. That's really where we're seeing all of the regulatory change around public charge is coming from the Department of Homeland Security. So the Department of Homeland Security has had public charge policies in place for a very long time. There's this 1999 field guidance that is still in effect today and has been in effect since 1999. And it defines a public charge as someone who depends almost exclusively on the government for very basic subsistence. And so because public charge is defined in this pretty restrictive way, there are very few public benefits that can be considered when making a public charge determination under that 1999 field guidance. So the only public benefits that can be considered are cash assistance or long-term care medical assistance that's used for a nursing home admission. Nothing else can be considered at all. For the most part, family members' receipt of benefits cannot be counted at all. There's one small exception for families that receive cash assistance and are using that cash assistance as the family's sole source of income. Under that circumstance, the family member's receipt of benefits can be counted against the green card or visa applicant who's subject to the public charge test. But any other public benefits received by family members cannot be counted against the person subject to the public charge test. So that's the 1999 field guidance pretty much in a nutshell. And like I said, it's still in effect today. It's been in effect since 1999. But we know that it will be changing. The Department of Homeland Security's public charge policies will change on February 24th. And on February 24th, the Department of Homeland Security will use the rule that it published last August. So if you are familiar with that rule, you know a little bit about what it says. I'm going to tell you a little bit about what changes are coming on February 24th. And I want to note that the change that's happening on February 24th is happening because the Supreme Court has allowed the Department of Homeland Security to put this rule into effect while the lawsuits continue. So there are 9 lawsuits challenging this new public charge policy. That all of those lawsuits will continue. And so the new rule that's going into effect on February 24th will be implemented at least until the litigation is complete. Hopefully the litigation will result in the rule being invalidated altogether, but we won't know that for some time. So on February 24th, this new rule will take effect. The new rule redefines public charge to mean anyone who is more likely than not to use any of the public benefits listed here over 12 months or more in any 36-month period. The public benefits that are implicated include cash assistance, federal medical assistance with the very important exceptions of emergency medical assistance for children under 21, and medical assistance for pregnant adults. It's important to keep in mind that in addition to the exceptions for emergency medical assistance for children and pregnant adults, also state-funded medical assistance is not included here. Only federal medical assistance is included. And we do have a small state-funded medical assistance program here in Pennsylvania that is available to many immigrants who are potentially subject to public charge. So anybody who's eligible for emergency MA, medical assistance as a child or a pregnant person, or who is eligible for state-funded medical assistance can continue to use those programs without any public charge risk. In addition to cash assistance and federal medical assistance, also SNAP or food stamps and housing subsidies and public housing are also included in the new public charge rule. So the new public charge rule, so you keep in mind, right, that the test here is when the immigration official is trying to figure out if you pass or fail the public charge test, what they're asking themselves is if you are likely to become a public charge in the future. And what the new rule says is that when that immigration official is trying to figure out if somebody's likely to become a public charge in the future, one of the things they can consider is if that individual received public benefits in the past. So if somebody subject to this public charge test has received one of those named public benefits for 12 months or more over any 36-month period in the past, from February 24th going forward, that past public benefit receipt will be negatively weighed. The rule also says that family members' receipt of benefits is not counted at all. And this is a good thing, right? This is actually a tiny little bit better than the 1999 field guidance that's currently in effect. So no receipt of public benefits by family members will be counted against the person applying for the green card or visa. The new rule is very explicit that it will not be retroactively applied, right? So any green card or visa application that is submitted before February 24th will be adjudicated under that 1999 field guidance. It will not be adjudicated under the new rules going into effect on February 24th. In addition, no benefits received before February 24th, besides cash assistance and long-term care medical assistance, will be considered at all, no matter when the green card or visa application is filed, right? So if somehow somebody is on food stamps now and they disenroll before February 24th, their past receipt of food stamps would not be counted against them during the public charge test. The new public charge policy is very clear that totality of the circumstances is still the rule. This has always been the rule, and that's not changing. And so what that means is that everything about the immigrant's life will be considered. So that if somebody is applying for a green card or visa and they're subject to public charge, their past receipt of public benefits, if they've had any past receipt of public benefits, that alone cannot make somebody a public charge. Everything else about that person has to be considered: their education and job history, their income, their family support, their resources. Everything is supposed to be taken into consideration. The new rule very explicitly names some things that immigration officials will be considering during this public charge test, and assigns different levels of weight that the immigration official conducting the public charge test will have to apply to all of these different factors in people's lives. I've listed some of them here. This is not all of them, but these are some of the biggies. So if you have your family has income under 125% of the federal poverty line, this will be negatively weighed against you. And if you have family income over 250% of the federal poverty line, this will be positively weighed in your favor. So if you're between 125 and 250, you don't have negative or positive. Assuming, we don't really know what that means. We presume there's some neutral zone there between 125 and 250. Being under 18 or over age 61 will be negatively weighed. Having a health concern that would require extensive treatment or that will affect your ability to work will be negatively weighed. Having no health insurance will be negatively weighed. Having unsubsidized health insurance will be positively weighed. So for example, if you have health insurance on the marketplace, you will not get a negative mark against you because you have health insurance, but you won't have a positive mark in your favor because that potentially is subsidized health insurance if you're getting subsidies through the marketplace. So again, another neutral zone factor there. English proficiency will be considered for the first time ever in public charge policy. Your education and employment history will also be considered. The affidavit of support will be considered, but it was not given nearly as much weight as it has been before. As I understand it, in the large majority of cases, if there was an affidavit of support that was valid and signed and in effect, that pretty much was enough to get people past the public charge test. That will not be the case anymore once this new rule goes into effect on the 24th. I have this timeline here just to give you all a sense. I find it helpful to kind of lay it all out in one place, because there have been a lot of changes over the last couple of years around public charge, and lots of different iterations of this new public charge rule have been filtering through different media outlets and getting into people's minds in different ways. So when you're talking with folks in the community who have lots of public charge fears, it might be that they heard one of these previous drafts or leaks of drafts of the public charge rule. Many of them were much worse than what we have ended up with today. And so some of their fears might be based on those, sorry about that. I don't know if you all can hear that, but there's a fire alarm going off in my hallway. I'm just gonna push through here. Oh, I think it stopped, good. So people, lots of folks who I am talking with have heard about some previous draft of the rule, which was much worse, and are much more afraid than they need to be. So if you're talking with folks, it might be that you can alleviate some of their fears just by letting them know that that previous draft was tossed and is not being implemented at all. It's been a long kind of evolution here. So starting back in February 2017, we started hearing rumors, and there were some leaked drafts of a new public charge policy coming through the media. And then that continued through most of that year. And then in January 2018, the Department of State made some changes to its policy that it uses overseas when making these public charge determinations. Then in October 2018, we finally got the first official proposal from the Department of Homeland Security about the new public charge rule. It added federal medical assistance, food stamps, housing subsidies, and some other public benefits to the list of implicated public benefits in public charge policy. We pushed hard, and there was a huge comment campaign that many of you were probably a part of. We got close to 300,000 comments submitted, almost all of them in opposition to the rule, and that really slowed down the process. We didn't get a final rule from DHS until August 2019. And the final rule was better than the proposed rule from October 2018. The final rule created the exclusion for medical assistance for children and pregnant people and people with emergency medical conditions. That final rule was supposed to take effect on October 15th of 2019, but it did not, because we had these 9 lawsuits that were filed very quickly. And the lower courts in those lawsuits put some temporary stays into place that kept the Department of Homeland Security from being able to implement the rule on October 15th. Around that same time, the Department of State proposed a new rule to adopt the Department of Homeland Security's public charge policies so that the Department of State could start using the same rules around public charge when it's making the public charge determinations overseas. Then, unfortunately, on January 27th, 2020, the US Supreme Court lifted the temporary stays on the DHS rule. But as I said, the Supreme Court decision was just about the temporary stays. It didn't say anything at all about the legality of the rule itself. So the lawsuits will continue, and we still have a chance that we will win in the end. And then on January 30th, Department of Homeland Security announced that it was going to go ahead with the permission the Supreme Court gave it to put the rule into effect, and that the new rule would take effect on February 24th while litigation continues. And that brings us to today. So this is pretty much kind of the summary, right? If you're subject to public charge and you're applying for your green card or your visa from inside the US, there are still lots of public benefits that you and your family can receive without any risk to your immigration status. And we're going to get into that a little bit more in the following slides. But if you are going to be applying for your green card or visa from outside the US, those folks really need to talk with an immigration lawyer. The Department of State, like I said in that timeline, back in January 2018, they started to change their policies around public charge, and they're trying to issue a rule, a final rule, but they haven't yet, to explicitly change their public charge policies. But because that explicit change to their public charge policies has not been made, there's a lot of confusion in the embassies overseas where these public charge determinations are being made. And a lot of people are being denied visas and green cards when they shouldn't be. So those folks really need to talk with immigration lawyers. But for those folks who are here in the US and are going to be applying for, are going to be subject to a public charge test here in the US, I really want to be very clear with those folks that there are really very few of those people whose benefit receipt will create any public charge risk for them. And there are three main reasons for that. The first is there is a very small list of public benefits that create any public charge risk, either under the 1999 field guidance or under the rule that will take effect on February 24th. And almost everybody who is subject to public charge is ineligible for all of those public benefits. All right, so even if they wanted to get one of these public benefits that would create a public charge problem for them, they wouldn't be able to get them because their immigration status makes them ineligible. That's the first. The second reason is that there are lots and lots and lots of other public benefits programs out there that create no public charge risk at all, and many of those public benefits programs are available to people who are subject to public charge. And then finally, family members' receipt of benefits is not counted at all under the new public charge rules going into effect on February 24th. So let's talk about that a little bit more. Starting with number one, there is this very small list of public benefits that create a public charge risk. And most people who are subject to public charge are ineligible for all of them. So the current public charge rules, that 1999 field guidance, only allows immigration officials to consider past receipt of cash assistance and long-term care medical assistance for nursing home admissions. That's the rule that's in effect today. On February 24th, that list will grow to include SNAP, federal housing subsidies, and federal medical assistance, with the important exclusions of emergency medical assistance, MA for children, and MA for pregnant adults. The large majority of people who are subject to public charge have an immigration status that makes them ineligible for all of those benefits. So to take the example of SNAP, or food stamps, in order to meet the immigration status eligibility criteria for SNAP, for the most part, you either need a green card or you need a humanitarian immigration status. People applying for green cards on family petitions don't have their green cards yet, and almost none of them have a humanitarian status. So their immigration status is going to make them ineligible for SNAP altogether. So even if they wanted to access that SNAP benefit that would create a public charge risk for them in the future, they won't be able to because their immigration status will make them ineligible. Second point, there are many public benefits programs that create no public charge risk at all. So all of these programs listed here are both available to people who are subject to public charge and create no public charge risk. So if somebody is subject to a public charge test here in the US, they can access any of these benefits listed here and many more public benefits that I don't have room on this slide to list without any risk to their immigration status at all. The medical assistance piece is probably the most confusing, right? Because federal medical assistance is listed in the new February 24th public charge rule, but it has all of these exceptions built into it. The February 24th rule says, yes, we're going to consider federal medical assistance unless you're a child or unless you're pregnant or unless you have an emergency medical condition. And we're not going to consider state-funded medical assistance at all. So there are lots of exceptions built into the rule that essentially mean that medical assistance for almost everybody is not going to be a problem at all under the new public charge rule. Third point, family members' receipt of benefits is not counted under the new public charge rules at all. This is very important. I get lots of questions from scared parents who feel like they need to be pulling their kids off their food stamps and medical assistance to reduce any public charge risk for them in the future. That's almost never the case. Under the current public charge rule, the 1999 field guidance, when an individual who is subject to a public charge test applies for a green card or visa, that individual family member's receipt of benefits cannot be considered. There is that one small exception. If somebody in the family is receiving cash assistance and the family is using that cash assistance as the family's sole source of income, this can be considered under the current rule, but that is changing on February 24th. Sorry. On February 24th, family members' receipt of benefits can't be considered at all. All right, so to recap, I just want to recap with some main takeaways from what we just discussed. The first is lots of people are exempt from public charge. Remember those first few slides. Refugees, asylees, VAWA petitioners, special immigrant juveniles, UNT visa holders, all of those folks are exempt. So if you are exempt from public charge, if public charge does not apply to you, you can receive any public benefits at any time without any harm to your immigration status. People who are subject to public charge and who will be applying for green cards or visas from outside the US. In addition, also people who have questions about how to sponsor their family members to come to the US from overseas. Those folks should talk with an immigration attorney. Like I said, the Department of State rules are in flux, and it's very confusing for folks. An immigration attorney might be able to help you put together the evidence you will need to pass that public charge test from overseas. People who are subject to public charge and who will be applying for green cards or visas from inside the US can continue to receive almost all of the benefits they are eligible to receive. These folks, right, so remember the new public charge rule that will take effect on February 24th will consider past receipt of public benefits, but it will also consider a lot of other things: your family income, your English proficiency, your education, your job history. So it's still important for these folks to talk with immigration attorneys so that they can figure out the best way to put together the evidence they will need to pass all those other elements of the public charge test. The point here, though, that I'm making with this in this bullet point is that disenrolling from public benefits will almost never be the answer for this group of people. There are very, very few people whose receipt of public benefits will increase their public charge risk here in the US. And then for those people who are subject to public charge tests in the US, your family members' receipt of benefits cannot harm your immigration status. This is really important. People should not be pulling their kids off of the food stamps and the medical assistance they're eligible to receive. So the fight continues. We are all fighting this, and we're going to keep fighting it. Like I said, the Supreme Court decision from January 27th was not a decision about the legality of the rule itself. The 9 lawsuits challenging the rule will continue, and hopefully it will end with the public charge rule being invalidated for good. And you can help. One of the main things we need to do now is make sure that immigrant communities are getting good information. There's so much misinformation and confusion and fear around this. Folks need a good source of reliable information, and we hope that you all feel like you can be that source. But of course, you can always reach out to me if I can help you make those connections with your communities. We, as part of our ongoing advocacy, we really value stories from people who are experiencing harm. So the Protecting Immigrant Families campaign has a lot of great resources, including a public charge harm reporting form that you can use. You can help folks in your communities use to report stories of harm. Why don't I pause here before diving into the case examples to see if there are questions I haven't seen.
I see one question that I think you covered, but maybe just a little bit more detail around public charge implications for an intending immigrant who lives in public housing or Section 8 housing with their spouse, with a sponsoring spouse. So I assume that means the spouse is getting the public housing maybe,
Yeah.
and their spouse, wife, or husband or partner is applying to become for a visa or green card.
Yeah.
How would what would be the public benefits or public charge implication?
Right. So in that scenario, I can only presume that it's the spouse that is the recipient of the subsidy, right? So probably the person who will be applying for the green card in that relationship has an immigration status that makes them ineligible for a subsidy, him or herself. The immigration status rules about eligibility for federal housing subsidies are in large part the same as the immigrant eligibility rules for food stamps, for example. So if somebody's just now applying for their green card, they probably do not yet have an immigration status that makes them eligible for that subsidy themselves. And so they're living with a partner who's getting the subsidy. So the partner, the spouse's receipt of the subsidy cannot be counted against the green card applicant during the public charge test. So there's no reason for that spouse to be dropping their disenrolling from the subsidy or moving out of the subsidized housing in an attempt to make it more likely that the spouse will pass the public charge test. They should keep the subsidy.
And then because I feel like this is the most common question I hear is, even though parents' names might be on the payee of the benefits for their children, that
Right.
still does not count against them because it's their children's benefits, correct?
Absolutely, yeah, yeah. So a mom with 2 U.S. citizen children might be getting food stamps and might be getting cash for the 2 kids, and when she gets the food stamps and the cash for the 2 kids, it'll come on an EBT card with her name on it. That just means that she's the person who's allowed to use the card to buy food for her kids. It does not mean that she is a recipient of those benefits herself.
And then the last question is, if someone is determined to be a public charge, what is the next step? Is there any type of appeal process?
That is a great question, and I would love to have an immigration lawyer here to ask that of. I am not 100% sure. I think the answer is no. I think that there is not an appeal process on a public charge determination. It does not. I don't think it means that all hope is lost in the immigration case. There could be other pathways to adjusting status in another way, but I do not know the specific answer to that, unfortunately.
That's all the questions.
Okay. Well, let's do a few case examples. I think that they're helpful just to get people kind of thinking about how this might apply to real life people. So I started here with a couple of easy ones, and then we'll move on to a couple more complicated ones. So Sarah came to the US on a temporary visa in January 2014. She applied for asylum, and after 4 long years, her asylum application was approved in 2018. Now she wants to apply for a green card. She's been receiving SSI, so cash assistance, SNAP, and federal medical assistance since June 2019. So, is Sarah subject to a future public charge test? I'll give you a second to think about it. No, she's not subject to a future public charge test because asylees are exempt from the public charge grounds of inadmissibility, so there will be no public charge test for Sarah when she goes to apply for that green card that she's thinking about applying for. But we know that Sarah might be really confused and afraid with all of this talk around public charge. She might think that she is going to be subject to public charge, and that she might be thinking that maybe she should drop her benefits so that she doesn't lose her status. But she shouldn't, right? She should keep her benefits on. This is kind of a classic example of how just getting some good information from a reliable source can make a huge difference in people's lives. Sarah is the prime example of somebody who just has no reason to fear here and who should not be even thinking about dropping her benefits. I have to add this little parenthetical here that she really needs to get her green card right away. As a public benefits attorney, I want to make sure people know people with asylum can only get SSI for 7 years. They are expected to get their green card and naturalize within those 7 years. So her SSI will end in 2025 if she has not become a US citizen by then. So she really needs to get on that right away. Susanna is our next case example. She came to the US as a child on a temporary visa that has now long expired. In 2014, she became a DACA recipient. In 2016, she met and married a US citizen. They now have 2 US citizen children. In 2017, her husband filed a petition and an affidavit of support for her immigrant visa and her green card. She got her green card in 2017, and now she wants, 3 years later, she's ready to start the application process to become a US citizen. They work, earn about $3,000 a month, putting them at about 140% of the federal poverty line. Her husband and children receive food stamps. She can't get food stamps yet because she's probably subject to that 5-year bar for food stamps. Even though she has her green card, she's still in that 5-year waiting period. Her children receive medical assistance. Her children receive WIC, and they use child care subsidies. And then she and her husband receive marketplace subsidies, Obamacare. Susanna, is Susanna subject to a future public charge test? No, right? She already has her green card. The next step in her immigration case is a US citizenship application. And there is no public charge test during the US citizenship application process. So she doesn't have a public charge test, but she might still be afraid, right? And especially somebody like Susanna, who's had a kind of a long and winding path in her immigration case. The confusion and fear out there might lead her to believe that she's one of these people who is at risk of being denied status or losing her status because of her use of public benefits. What should she do? Well, she should just keep her and her family benefits on and continue with her US citizenship application process. All right, so those were the easy ones. These next few are a little more complicated. So Sylvia and Samuel both came to the US as children on temporary visas, just like Susanna. The difference here, right, is they're married, but they're both DACA recipients, right? Whereas Susanna was married to a US citizen. Both Sylvia and Samuel are DACA recipients, and they have 2 US citizen children. They're working and they're earning the same amount of money, $3,000 a month, putting them at 140% of the federal poverty line. Their children receive SNAP, medical assistance, and WIC, and they use child care subsidies. All right, so Sylvia and Samuel, they probably do not have a public charge test in their future, right? They do not have a public charge test during their next DACA renewal. Public charge is not part of the DACA renewal process, so there's no reason for them to fear public charge when they're thinking about whether they can keep their DACA. If they become eligible at some point in the future for a green card on a family petition, they might be subject to a public charge test in the US at that time, right? So this is a little more uncertain for Sylvia and Samuel. They can talk with an immigration attorney about what their green card options are. And really, no matter what their green card options are, they should keep their benefits on, right? Because even if they will become eligible for a visa or a green card in the future, and they'll be subject to that public charge test in the US as part of their visa or green card application process, there are no benefits that they or their children can get now that will increase their public charge risk in the future, right? So keep in mind that the new public charge rule does not consider family members' receipt of benefits at all, so there's no reason for their kids to drop the food stamps or the medical assistance or the WIC or the child care subsidies or any of that. The new rule does not consider any benefits that are available to people with DACA at all, right? So for example, the new rule does not consider emergency medical assistance, it doesn't consider WIC, it doesn't consider charity care or services like medical care at an FQHC or food at food pantries or food cupboards. FQHC is a federally qualified health center, so community health clinics, the city health centers here in Philadelphia. There's no reason for Sylvia or Samuel not to use any of those services or access any of those public benefits if they become eligible for them. So in terms of their access to public benefits, really nothing changes with this new rule. That's Sylvia and Samuel. Sandra has been living in the United States with temporary protected status since 2010. In 2016, she met and married a US citizen, and now they have 2 US citizen children. In August 2019, after hearing news that the TPS designation for her country might be canceled, she and her husband started looking into the process of filing a family petition and an affidavit of support for Sandra's immigrant visa and green card. And now, on February 12th, 2020, they're now ready to submit that application. Just like Susanna and Sylvia and Samuel, they work. They earn about $3,000 a month, putting them at 140% of the federal poverty line. Her husband and her children receive SNAP. Her children receive medical assistance. Her children receive WIC, and they use child care subsidies. And then she and her husband receive marketplace subsidies. She also received TANF for a little bit when she was pregnant with her first child. What about Sandra? Is Sandra subject to a future public charge test? The answer here is yes, right? She will be subject to the Department of Homeland Security's public charge test here in the US when she applies for that lawful permanent residency status through the family petition that her husband is going to file. What should she do? Well, there are a few things. The first thing she should do is talk with her immigration attorney about filing that green card application now, if possible, right? If she gets that application in before February 24th, it will be adjudicated under the old rules, not the new rule. And the new rule, remember, under the current rule, the 1999 field guidance, if you have an affidavit of support in effect that is pretty much dispositive, it gets you past that public charge test, and the definition of public charge is much more narrow, right? A public charge is someone who depends almost exclusively on the government for very basic subsistence. So it's an easier public charge test to pass. So if she can get that in before February 24th, 2020, she will have a better chance of passing the public charge test. But if for some reason she can't get the green card application filed by February 24th, all hope is not lost. She should keep in mind that the new public charge rule does not consider family members' receipt of benefits, so there's no reason for her husband and kids not to get benefits or to disenroll from the food stamps and the medical assistance that they're getting. She should keep in mind that the new public charge rule does not consider marketplace subsidies or WIC or child care subsidies at all. So there's no reason for anyone, even Sandra, to be dropping marketplace subsidies or WIC or child care subsidies. The new public charge rule does not permit retroactive application. So her receipt of medical assistance before February 24th will not be considered. And I should point out that when she got TANF, when she was pregnant with her first child, she also would have received federal medical assistance when she was pregnant with her first child. But her past receipt of medical assistance will not be considered because it happened before February 24th. It also wouldn't be considered because it was medical assistance for a pregnant woman. And she should also keep in mind that totality of the circumstances is the rule. Yes, she received cash assistance, TANF, in the past. And cash assistance is one of the benefits that can be considered even under the current rule, right, under the 1999 field guidance. But that alone cannot make her a public charge. It happened a long time ago. Things have changed a lot now. She's working. Her family's income is over 125% of poverty. She has a lot of significant factors that will be weighed, if not, that will not be weighed negatively against her, and some will be weighed positively in her favor. So she should talk with her immigration lawyer about how to put together the evidence she will need to pass this public charge totality of the circumstances test. And I have one last case example, and it's a continuation of Sandra's story. If things got bad for Sandra, if a crisis occurred in her family, things would look a lot different, right? So this is unfortunately what happens to Sandra on February 13th, 2020. So they're just about ready to submit that green card application. She and her husband are just about ready to submit it, but then things get bad. Her husband is injured at work. He can't work, and Sandra finds out she's pregnant. She's having a difficult pregnancy. Her doctor has advised her to reduce her hours at work. Her husband's trying to get workers' compensation, but his employer is fighting it. Their income is now a lot lower. It's closer to $1,000 a month, putting them at about 45% of the federal poverty line. Her husband and children's food stamps have gone up. Generally, when your income goes down, your food stamps can go up. She and her husband now also receive medical assistance along with their children. She now receives WIC along with her children, and they're using childcare subsidies. Sandra is afraid she won't be able to work much longer, and she's thinking about applying for TANF, for cash assistance again. So Sandra is now, she certainly is still subject to that future public charge test. She should still talk with her immigration lawyer about getting that green card application filed very quickly if she can. But even if she can't, things will get a lot harder for her, but all hope still is not lost, right? The new public charge rule doesn't consider her family's receipt of benefits. There still is no reason for her husband and kids not to get the benefits that they're eligible for. The public charge rule does not consider WIC. Even if Sandra is receiving WIC, it doesn't count WIC, so there's no reason for Sandra to drop the WIC that she's receiving for herself or her children. The public charge rule does not consider medical assistance for pregnant woman, and this is even after February 24th, right? So even if she gets medical assistance now and she keeps it on past February 24th all the way through her pregnancy, that cannot be counted against her at all. So that there's no reason for Sandra to drop the medical assistance she's receiving. Totality of the circumstances is still the rule. But so what that means is that she will have to think really, really carefully about whether or not it's worth the risk to start receiving TANF if the family needs it, right? So that receipt of TANF, if they start receiving it, will be heavily weighed against them. And it will put them pretty much directly at risk for a public charge determination. You know, families who need TANF really, really need TANF. They are living in the deepest levels of poverty that we have here in the state of Pennsylvania. So it might be that Sandra, after considering all her options, decides that it's more important for her family to get that support from TANF rather than, you know, that's more important than the public charge risk that puts her at. She might decide that she wants to put off the green card application after talking with her immigration attorney. There are lots of different options, but she does need to think carefully about it and talk with her immigration attorney and perhaps a public benefits expert to think through all of her options there. And that's our last case example, right at the end of the webinar. Any other questions?
Thank you, Maripat. I think your last case study answers a lot of what our last question was, which is, what do we say to parents who remain scared to keep their children enrolled in Medicaid because they're concerned that the rules are going to change in the future and they'll get penalized for enrolling their kids now? And I believe the one answer is usually these things are not applied retroactively, so applying for benefits now is probably not going to harm you in the future. And two, family members are not counted, so parents should do everything in their power to keep their benefits for their children so that they have the resources they need to keep their family healthy.
Yeah, I think that's right. I mean, this new public charge rule, the public charge rule that's taking effect on February 24th is very explicit about it not being retroactively applied. And in order for the rule to change again, it would have to go through a very long process with a whole lot of warning to the world that the rule was changing again. Remember, it took almost 3 years now. We've been doing this, and it's just going into effect now. And we've had lots of time to kind of think about how this might affect people's lives. And the regulation making process is long for a reason. It's to give people some notice about what's coming up for them in the future and giving them a chance to fight back. So yes, the rules can change in the future, but not in such a way that people wouldn't have a chance to make adjustments in their life if that was happening.
Great. Well, thank you so much, Maripat, for this great presentation. We did record this webinar. We will be posting a copy of the recording of this webinar along with the slides that were covered on the PIC website at www.paimmigrant.org. We have a public charge toolkit that also has links to past webinars that we've done over the past 2 years, as well as links to the Protecting Immigrant Families campaign, which has put together some fabulous public education materials, many of which are translated into many, many languages. So if you are working with community members, I strongly recommend looking at the Protecting Immigrant Families website and using their materials because they're already translated, so you don't have to do it yourself. So thank you very much, everyone, and we will talk again later, I'm sure. There's something else coming up.
Thanks.